Judge, let me know when you're ready.
We're on.
Wendell's.
Wendell's coming.
Back there, Phil.
Sound like a little rat back there.
Mr. Chairman, I'm ready if you are.
I call this second day of regularly scheduled Real Estate Commission meeting in the session. And at this time, I'm going to turn the proceedings over to our judge, who is going to be handling these proceedings for the state today. And, Your Honor, the floor is yours.
Thank you, Mr. Chairman. Members of the board, we have got one case on the docket this morning. It's the matter of Gary T. Moore, which is docket number 12.18-125-451A. Is there anyone here on behalf of Mr. Gary T. Moore, or is Mr. Gary T. Moore here? Does not appear so, members of the board. So at this time, we'll begin the hearing, and we will, in a few minutes, get to the issue of the default of the respondent. I am Mary Collier. I think most of you have met me before. I'm the judge assigned by the Administrative Procedures Division to preside over the hearing. Sitting with you this morning, sitting next to me is Judge Michael Begley, who I just introduced to most of you. He's not going to rule today. He's just here observing. He's the newest member of our central panel of judges. Today, I will make all of the rulings regarding the order of proceedings, the admissibility of evidence, and the questions of law under the authority granted to me under the Tennessee Administrative Procedures Act. I will not participate in the findings of fact or the ultimate decision of the board. Those decisions will be made by you all at the conclusion of the hearing. At this time, I'd like to begin with an introduction of all the board members. I know you have your name tags, but it's easier for the record and the court reporter if you'll announce who's here, please.
Wendell Alexander.
Harry Bloom.
Marcia Franks.
John Priest.
Bear Stevenson.
Janet DeChara.
Over Collins.
Austin McMullen.
David L. Flaycroft.
Thank you, members of the board. Counsel for the state, would you all like to introduce yourselves?
I'm Robin Ryan. I'm here for the state, and these are Julie Kropp, who is the board for the attorney for the board, and then Eve Maxwell, who is the executive director.
Thank you, Ms. Ryan. Members of the board, at this time I'm going to ask Ms. Ryan to pass to you a copy of the notice of hearing and charges in this case. That is the first document that I have in my file. It's not a very thick file. It looks like I have 4 documents, and I'll identify those for you now. That first one she's passing a copy to you of now. The second document in the file is the pre-hearing order that I issued on April the 24th of 2014. Actually, Ms. Ryan, looks like the third document is the amended notice of hearing and charges.
I have both of them for you.
Okay, if you'll pass both of those to the board, please, ma'am. That was filed in my office on April 24th of 2014. And then the fourth document I have in the file is the witness and exhibit list filed by the state. As you take a look at the notice of hearing and the amended notice of hearing, members of the board, I would ask you all to verify that you all do not have any prior knowledge of this case. If you do have any prior knowledge of this case, the law requires you to disclose on the record that outside knowledge of the case and in what format you received it, whether it was written, verbal, or some other type of communication. During the hearing today, there should be no discussion of the case other than here in the board room on the record. There should be no discussion during breaks between commission members, witnesses, attorneys, or members of the public regarding the case. Instead, all discussions of this case should be here in the hearing room. The commission during the hearing sits like a jury and must consider only the evidence that is introduced during the hearing this morning. The Tennessee Sunshine Law requires that all commission discussions and deliberations be in public before all parties who choose to be present, and a failure to comply with that could result with the commission's action being reversed or remanded if appealed to a higher court. You should not draw any conclusions until all of the proof has been submitted this morning, and you should listen openly to all proof regardless of which side submits the proof. Members of the board, now that you've all had a chance to review the notice of hearing and the amended notice of hearing, does anyone have any prior knowledge they need to disclose on the record? Thank you. Ms. Ryan,
Honor,
do you have a motion for default?
I do, but before we go further, I just wanted to just put on the record that this respondent has indicated that he sent emails to all the commissioners concerning this matter, although anonymously. I don't think any of them have read it, but I did want to have that on the record.
Thank you. Members of the board, commission, have any of you received an email that you have read regarding this matter? Apparently none of them read it. Thank you, Ms. Ryan.
I'm ready to go forward. I would like to make a motion for default, and I'd like to move on proof of service.
All right, go ahead.
This matter was sent by certified mail and regular mail at the address that was listed with us. That is, the address listed as a licensee, and that is P.O. Box 791, Brentwood, Tennessee. And this is the same address where mail was accepted by the respondent from the board on December 23, 2013. However, the notice of hearing and charges was returned to sender unclaimed. Also, I want the court to know that none of the regular mail has been returned. To follow up with that, on May 9th, our paralegal, Jenica Smith, called Mr. Moore to ask if he had received a copy of the amended notice that was sent and marked unavailable for pickup on May 1st. That has not been returned. And Mr. Moore has not said he did not receive the amended, and he would not confirm whether he had or had not received the original notice of hearing. A witness and exhibit list was sent to him via regular mail on May 21st and has not been returned. On May 9th, Ms. Smith emailed a copy of both the notice of hearing and amended notice of hearing, and further sent copies of both to the home address listed with the state, 5110 Pheasant Run Trail, Brentwood, Tennessee, and that mail has not been returned. Additionally, she sent the mail to 5115 Maryland Way, an address that was shown for the real estate a la carte where he had worked, and that mail has been returned. On May 18th, she confirmed that an email that she had sent had been read, and Mr. Moore has responded to Ms. Smith via email on May 21st. To further this, I would like to put on Ms. Jenica Smith to get the full facts on the record.
All right, thank you.
Your Honor, may I say, now that she has said Brentwood, I did receive an email from this person, so I'll need to recuse myself.
Hold on. You may recuse yourself if you'd like to, but if you are able to participate in the proceedings fairly and in an unbiased fashion and only regard the proof that's put in today, you could proceed. I believe we would have a quorum if we lose one member. Is that right, Ms. Ryan?
That's correct.
So are there any other people that recall they've seen this email?
May I ask if she read the email?
I did read the email.
Okay.
I don't know the person.
Okay. Again, since we still have a quorum, if you want to recuse yourself, you can. But I wanted to make sure you all understand, as long as you can disregard it, we can let you proceed. But since we've only got one person, the recusal of one person would not affect the board.
Hey,
So-
I've served jury duty several times, and I feel like I could be fair in this case since I don't know him.
Okay. Well, again, what I'm saying is because we have a quorum without you, if you'd like to recuse yourself, that's fine, and that simplifies the matter. I wanted to make sure before we found out if everyone had seen the email, then we'd have to have some more discussions. But I think it'd be fine for you to recuse yourself since we'd still have a quorum.
Okay, then that's what I'll do.
Okay. Thank you, Ms. Franks. So I'll let you, if you wouldn't mind, I'm going to ask you to leave the panel since you've recused yourself. Otherwise, it gets confusing. Thank you, ma'am. And members of the panel, again, this happens a lot. All of a sudden, you remember something that you got 3 or 4 months ago. Has anyone and everyone else, no one else remembers getting this email or any communications? All right, excellent. Now we've got Ms. Smith, is that correct? Please raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you. Please state your full name for the record.
Jenica Smith.
Go ahead, Ms. Ryan.
Thank you, Ms. Smith. And what position do you have with the state of Tennessee?
I'm a paralegal for the Legal Division of Regulatory Boards.
Does that mean you're also a paralegal for this division, that is the Real Estate Commission?
Yes.
What communications or what attempts of communication have you had with Mr. Moore?
I had a phone call with him on May 9th.
And what was the gist of that phone call?
I was calling to verify that he received the amended notice of hearing and charges.
And did he tell you he had or had not?
He told me that he had not.
Did he say anything about the original notice of hearing and charges?
No, he did not. He hung up.
He hung up. Did you ask him or try to get a different address or anything for him?
When I was trying to verify the P.O. Box address is when he hung up on me.
And what did you do after that phone call?
I looked through the file and obtained an email and emailed him the amended notice of hearing and notice of hearing and charges.
And what was the date you emailed those documents to him?
May 9th.
Were those emails returned to you?
No.
Did you get confirmation that the emails were read?
Yes, I received a read receipt confirmation on May 18th.
And as a result of the conversation with him, did you attempt to find other addresses for Mr. Moore and or Real Estate a la carte, which is his business?
Yes, I looked up his business on the Tennessee Secretary of State and obtained the Pheasant Run Trail address. And I performed a Westlaw Clear search and obtained the Maryland Way address.
And did you send documents to both those addresses?
I sent both the amended notice of hearing and notice of hearing and charges.
And were any of those documents returned?
Let me verify which one. We did not get a return on the Pheasant Run Trail. The Maryland Way address was returned undeliverable on May 23rd.
And the Pheasant Trail, is that a business address or the home address?
That is the principal office designated on Tennessee Secretary of State website.
And we received no return mail from that address at all?
That is correct.
And when is the most recent time you spoke with Mr. Moore?
He sent me an email on May 21st.
Okay, that's the last communication you had with him?
Yes.
And in that mail, did he indicate whether or not he planned to attend today?
He indicated that he did not plan to attend.
Thank you. Your Honor, I would ask and move for a default judgment. And also enter the documents where the certified mail was unclaimed to return to sender.
All right, if you'd pass that up to the court reporter, please. Same document?
That's correct.
Yes, so that would be marked and entered into evidence as exhibit number 1. And that's from the notice of hearing?
What's the number on it, Your Honor? Or what's the date on it? April 8th?
April 8th?
Yes, that's the notice of hearing and charges.
Thank you. Members of the board, do you all have any questions for Ms. Smith regarding the service and her attempts to verify that Mr. Moore had knowledge of today's hearing? All right. Ms. Smith, did you all ever try to make actual service other than by mail? Like
Being in
personal service
person?
via person?
No, Your Honor.
Okay. And when did you receive the email that stated he was not planning to come today?
May 21st.
You have that with you?
Yes.
What precisely did he say regarding the hearing?
Would you like me to read the entire email or just
I just need
regarding
to know what he
hearing?
says about whether or not he's coming to the hearing.
Please do not go to any trouble preparing staff or anyone to prosecute me at any proposed meeting or hearing. I will not attend any proceeding in which I am required to pay, especially several $1,000 as staff notes below, to answer a complaint.
Thank you. Any other members of the board have any questions? All right, members of the board, based upon the, thank you, Ms. Smith, you may step down. Based upon the information that Ms. Smith has provided, as well as exhibit number 1, and in addition to that, there is the fact that my office sent the order I mentioned earlier, dated April the 24th of 2004, to the P.O. Box address, which is his address of record with the Tennessee Real Estate Commission. That has not been returned to my office. Based upon the multiple attempts at service and the fact that after all of those attempts at service via multiple different methods, Mr. Moore stated to the paralegal for the legal division that he was not coming to the hearing. I find first that he had sufficient notice of the hearing, and that's under our rules 1360-04-01-.06. and I find that he has chosen not to be here. So based upon that, at this point, I turn over to you all the actual issue of the default and whether or not you want to hold him in default. Under Tennessee Code Annotated 4-5-309 Subpart A party may be held in default when they fail to attend or participate in a pre-hearing, conference hearing, or other stage of a contested case proceedings. And that decision is up to you, the members of the commission, who are here this morning and present for the hearing, to determine whether or not you want to proceed in default against Mr. Moore. Mr. Chairman?
Having heard the evidence,
Mr. Chairman?
Mr. McMullen.
I move that we proceed in default against the respondent.
I have a motion by Mr. McMullen that we continue with these proceedings and him being held in default.
Second.
Second by Commissioner Grease. Is there any discussion on the motion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries, and we will proceed with he being in default.
Thank you, members of the commission. Ms. Ryan, would you like to make an opening statement?
I would. This matter is here today based on a failure of this respondent to make sure the firm where he was working was licensed at the time he was working there. Proof will show that he is licensed, although he's now in retirement, and that retirement occurred after this matter was pursued. The proof will further show that the expiration date for that license is July 17th of 2014. The proof will show that the respondent is and was at all times the principal broker of a real estate firm, A La Carte LLC. That is the firm in question that was unlicensed for a period of time. Proof will show that that firm license expired on February 1st of 2013 and was not renewed. Proof will further show that the advertisements in May of 2013, July of 2013, and November of 2013 show that respondent was active advertising with this firm. We will further show today that the respondent attempted to reach each of you concerning this matter and did not agree to a consent order or any other resolution. But he never addresses the issue at hand, and that is the unlicensed firm, and why that license was not renewed, and why, indeed, even after receiving notice of it, he didn't make an attempt to renew that license. You will learn that it has never been resolved, and while he is still in retirement, the firm license is still expired. And as you well know, in retired status, they can come back and renew their license. The firm license, although has been expired for over a year at this point, and you also know that the violation here is a violation, we believe, of 6213-312. That is 14. That is for violations of 6213-309, which states everybody who's working in a firm must work at a firm with a license. It has to be a licensed firm. At the end of the proof today, we'll ask that you assess a civil penalty and that you require him to pay all court costs for the proof that's shown that he has advertised and continued working in a firm that was not licensed. Thank you.
Thank you, Ms. Ryan. Who would you like to call as the state's first witness?
Eve Maxwell.
Please, thank you. Please raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. Ms. Maxwell, please state your full name for the record.
Let me move my chair. Sorry. Eve M. Maxwell.
Thank you. Go ahead, Ms. Ryan.
And Ms. Maxwell, what is your position with the state of Tennessee?
I'm the Executive Director of the Tennessee Real Estate Commission.
And as the Executive Director, are you familiar with complaint files and license files of licensees?
Yes, I am.
And as the Executive Director, are you familiar with both the complaint file and license file of this respondent, Gary Moore?
Yes, I am.
Does he have a current and active license?
He has a license that's in retirement. It was placed in retirement on 12/3 of 2013.
And
he has license number 16853. He was a principal broker prior to his retirement, at which time he was, when he retired, he went from principal broker to a broker.
And do your records show at what firm he was the principal broker?
He was the principal broker at a firm, Real Estate A La Carte, that's C-A-R-T-E, LLC, license number 259633. 39. It was first issued a license on 2/2 of 2007 with Mr. Gary T. Moore as the principal broker at that time. And the license expired on 2/1 of 2013.
Have your records show any attempts by this respondent to reactivate that license?
No, there have not been any attempts, according to the track records.
So that license expired in February of 2013?
That is correct.
What was the reason this complaint was filed?
The complaint was originally filed, we got a consumer complaint about advertising that was being conducted by Mr. Moore that the complainant thought violated the Broker Act. And so we opened a complaint based upon that.
And in your review of that, did you then find that...
At that point, yes, when the complaint came in, we started to review the complaint. We realized that his firm had expired during, well, actually, at the time, about 4, 5, 6 months, but prior to that.
Prior to the complaint being filed?
Prior to the complaint being filed.
Was a copy of the complaint sent to Mr. Moore?
Yes, it was, and it was sent certified mail to Mr. Moore at Real Estate a la carte, LLC, Post Office Box 791, Brentwood, Tennessee 37027, and it appears that it was signed for by Mr. Moore. Let's see if I can find the date. It was signed for by him on December the 23rd, I believe, 2013.
Has he ever addressed with you or any member of your staff the issue of the firm not being licensed?
No, he has an email that he sent to me after the consent order had been issued. And
when that was?
That was on, his email was sent to me on January the 22nd.
Do you know when the consent order was sent to him?
The consent order was, oh, I'm sorry, I was reading the dates of the consent order when I read the service for the complaint. I'm sorry. Let me correct myself. I'm sorry. I read those dates. I was just looking at that certified mail. The complaint was sent to him certified mail July the 10th and signed for by him on July the 10th of 2013. I'm sorry. The consent order was sent and signed for him by December the 23rd of 2013. So he signed for both of them.
Okay, between the time the complaint was sent to him and the time the consent order was sent to him, did he respond at all about the issues?
He responded to the complaint. He filed a response, and that response was dated July the 16th of 2013, and it was in the form of a letter. As opposed to a more formal response, it's in the form of a letter, and it addresses several of the issues that were in the complaint, which were advertising issues.
Has he ever addressed with you or anyone else in your staff the issue of the unlicensed firm?
No, he has not.
Now, after this complaint was filed, did you do any individual or investigation about whether or not he was practicing still and whether or not there were any advertisements?
Yes, I went on the internet at the time that I reviewed the complaint and received the email from the individual about the complaint and found that there was advertising at that time by a la carte and Mr. Gary T. Moore on the internet. He had a website. That was on several different websites that dealt with Brentwood real estate listings, and then the actual site of Real Estate a la carte, buying and selling real estate will never be the same. And it was a fairly involved site that had a number of articles basically that had been written by Mr. Moore describing a rebate program that he had and how you could get financing and a number of things that his firm offered on an a la carte basis.
Now, were there any indications or any review by this board whether those advertisements in and of themselves were in violation of the law?
No, there was not.
Okay. And so what were the dates of the times you looked online?
I looked online when the complaint came in, which was in July of 2013, I actually looked online this morning. There
And?
was still some advertising as well.
There's still advertising online?
Yes, there's still some advertising for
Indicating
a la carte.
that it is an a la carte real estate firm?
Indicating that the firm is, that Mr. Moore is still out there engaged in business. Not under his, there's under a website called Videos, like a video website where they do walkthroughs of houses, and it's got the a la carte symbol on it, which.
And a la
Mr.
carte
Moore-
is the business firm, is that correct?
It's his business firm, right.
That is not licensed.
It is not licensed.
And his.
And he's in retirement at the current
Okay.
time.
Okay. I would like to show you a copy of the complaint file and see if you can identify it for me. May I approach the witness?
Yes.
Yes, I believe part of these, there's the email that was sent to the commissioners that's dated in February, or that was allegedly sent, so that we didn't send that up initially with the
Right.
complaint file. But the rest of the information is information that was in the
If
complaint
you look
file.
at the attachment, the first attachment that looks like an advertisement, the date at the bottom is 11/22/2013. Can you pull that?
Yes, I see that.
And in that advertisement, can you look and tell me whether or not a la carte real estate is listed as the firm in this case?
Yes, at the heading of the first home that's shown, it says real estate a la carte, and it has the, what appears to be the little trademark symbol of a la carte real estate, and then it has, the website itself is called Real Estate a la carte, and then it has other information, and the number listed here, 615-579-8658, is the number that was on file with Trek for Mr. Moore's firm a la carte.
Look at the back, when it says a la carte buyer's rebate from Gary Moore Homes for Sale, Brentwood, Tennessee, one of 15 pages. It's the last exhibit included in this complaint file.
Did you ask if that was the last page? or-
Well,
I'm
it's the
sorry.
last exhibit attached to the complaint file. Let me help you a bit, Ms. Maxwell. It looks like, did you find it? Looks like that.
The buyer's menu
Yes.
starts, okay.
Was this something that was presented to you in your initial review, or is this something you found after looking at this matter?
This was presented to, this was presented to us in our initial review, the information about the rebate program and the cash-in prizes.
What is the firm listed at that particular place?
This is listed as real estate a la carte. Buying and selling real estate will never be the same. Home of the buyer's rebate.
And again, that's the same firm we're speaking of earlier.
That is correct, and there's a picture of, I guess, of Gary T. Moore over on the left-hand side of the page.
And when you're looking at that, you opened the complaint when? What month?
July of 2013, I think it was the 3rd of July, 2013.
So this advertisement was sometime presented to you, you got it in July 2013. Do you know the exact date or the date the complainant initially was complaining about?
That the email came in from the complainant? May the 11th of 2013.
Was real estate a la carte licensed at that time?
No, it was not.
Okay, so we know that in May and we know in July, there were two advertisements listing real estate a la carte, is that correct?
That's correct, and then this additional information is dated 11/22/2013.
So we're looking at May, July, and November, is that correct?
That is correct.
Okay. Did he ever communicate with you directly?
He did communicate with me directly after he received the consent order.
Was that by email or regular mail?
It was by email.
What's the date of that email?
The date of his email to me was January the 22nd, 2014.
And what did he say in that email?
Do you want me to read the email?
Please.
Okay. To Eve Maxwell, Executive Director, Tennessee Real Estate Commission. Ms. Maxwell, Russ Fair, counsel for the Tennessee Association of Realtors, asked me to call you and provide some information which he believed was relevant to a consent order recently propounded on me. I'm sorry to have missed you on the phone, as I'm sure you have had your hands full. This consent order rode on complaint number 201-301-331, although the complaint was found without merit by TREC counsel Julie Kropp, as agreed by the commissioners at your December 2013 meeting. Last year was my 37th year since becoming a realtor in 1976. I got my broker's license as soon as I could 2 years later. I have trained agents and held workshops for realtors and consumers. I've been a home builder and a mortgage banker at stretches along the way. In the practice of real estate, I've always put my customers first, and I prided myself at being scrupulous with the rules. I've been found compliant after being personally audited by Eddie Sneed of TREC in 2 of the last 4 years. On my webpage, which you attached to the now moot complaint, I went so far as to quote chapter and verse of 1260-02-.33 in TREC Rules of Conduct, as well as providing the TREC link. Therefore, I confess it is unsettling and embarrassing to be viewed as one of those who gets written up in the TREC newsletters like we used to get in the mail. It is further unsettling to be sanctioned without the commissioners having any input or information from me. I have not been recently active in real estate. I was engaged in the mortgage business as an employee of financial institutions from 2001 to 2012 and have had no income since. I have actually not been involved in a real estate transaction in more than 2 years. I've had no agents under me at any time. I received zoning and occupancy credentials from the City of Brentwood to use my home as the real estate office. In August of 2012, seeing that I was not going to be in a position to accept earnest money as a result of being a listing agent, I applied for and received a waiver of escrow from TREC. I retired my broker's license in November of 2013. The underlying complaint, dated July the 8th, 2013, was not what I think of as a complaint. It did not involve a transaction in which a realtor allegedly put his or her interests above those of a customer, nor did it involve a dispute of any kind. This complaint, as such, derived from a realtor who smiles to my face, trying to use TREC as a club against me as his perceived competition. Regrettably, that was not seen for what it was, and you elevated a 2-line email to a formal complaint. I responded to the complaint, which was posed to me by TREC as an advertising issue. Ms. Kropp, at your December meeting, advised the Commission there were no violations found as had been alleged. At your December meeting, however, Ms. Kropp presented to the Commissioners the information that my firm license had expired in February of 2013. She recommended a $1,000 fine and other penalties attendant only to the license expiration subject. Unfortunately, I believe the matter of the firm license was prejudiced by being coupled with the advertising complaint. Further, I was afforded no opportunity to be heard regarding the firm license subject, unlike the advertising subject. Ms. Kropp advised that I must either pay the fine and comply with the entirety of the consent order, or else it would be elevated to a formal hearing, which would include costs assessed to me. She estimated such costs could be $2,000 to $3,000. To require me to pay to provide my input is unfair, and it cuts me out and prices me out of any rights to due process. Further, a hearing with judge, attorneys, court reporter, etc. is not practical, efficient, or appropriate for this matter, which does not involve witnesses who have conflicting stories and interests centered around a transaction or incident. Will you please allow me to attend your February meeting and offer my input on this? Or will you provide some written information from me which you could present to the Commissioners along with a motion to reconsider? There is usually more to any matter than meets the eye. The simple fact is that I did not receive the firm renewal in the mail from the Real Estate Commission, although for 36 years I successfully relied on getting those to prompt renewals. I know you would say it's my job, too, to keep up with this, and probably that you did mail a renewal. I suspected the waiver of escrow account obtained in August of 2012 and its language triggered the firm license not being sent out for renewal. However it came about, that itself is not especially important at this point. I asked Ms. Kropp if she or the Commission believes that someone would intentionally not renew a license. I would hope that you and the Commissioners would not think something like this is done willfully. At all times, I was qualified to renew the firm license with no unmet conditions, so it was not like for some reason I could not obtain the firm license and sought to get away with something. In November of 2012, I received in the mail my E&O renewal, and I paid $257 to renew it for 2 calendar years. That month, I received in the mail my Williamson County Association of Realtors annual renewal for calendar year 2013, and I paid $511. The state mailed me a bill for $400 in May for annual privilege tax, and I paid that. In July, the city of Brentwood mailed me their annual zoning and occupancy renewal, and I paid that. Every month, I pay about $80 to RealTrax. So there was no intention to not pay the $80 biannual firm renewal on its uneven date, which is unlike the above calendar-based annual cycles. If I had agents under me, I would view this differently. I believe that would make a difference. I would not complain. If I had been an active realtor myself, involved in transactions and receiving commissions, I would not be complaining. I believe under the circumstances of having no agents and no activity, and now having retired my license so as to stop the condition of the firm being an issue, no harm has been done. Rules of Conduct 1260-02-.324 states, in determining the amount of a civil penalty, the Commission may consider such factors as the circumstances leading to the violation, the severity of the violation, and the risk of harm to the public, the economic benefits gained by the violator as a result of noncompliance, the interest of the public. There's been no harm to the public. No one or nothing or no one has been impacted. I have not personally benefited. As disturbing as it was for me to learn the firm license had gapped, I hope a 37-year track record counts for something. I do not believe I've done anything morally wrong. In general, the object is to make things whole or to put things back as they would have been. Under that concept, a payment of $80 would seem appropriate. I would offer that there is an opinion that I must be punished, suspend my license for a period of months. In another matter that came before the Commission on December 4th of 2013, the first matter on your docket resulted in a $500 penalty for unlicensed activity. I had no activity during any of this time. I am not sure why the amount of this civil penalty was half of mine. Does my license status become suspended at this point, even though I have not had a chance to provide my information? I would like for my license to be in good standing, even if temporarily retired. If we put down legalistic blinders and view this on the basis of common sense, I think that we would all agree that no harm came about, and this was just one of those things. Can there be room at TREC for one of those things? Please let me know what you think, and if you have questions. Thank you for considering this matter, Gary Moore.
Thank you. In that letter, he said he retired his license.
Your Honor, this gentleman called me.
He called you? Okay. Did he call anybody else? How many members is a quorum?
5.
Bloom, would you like to continue to participate, or would you like to recuse yourself based on that prior knowledge and communication by the respondent?
It doesn't. I probably need to recuse myself.
All right, that's fine. We still have a quorum with 7 members of the panel, so Mr. Bloom will let you recuse yourself and step down from the panel.
Ms. Maxwell, in that letter to you, he states he retired his license in November of 2013?
Right. He signed the TREC 1 form in November. It did not arrive and go through the cashier's office and come into our office for approval till December the 3rd of 2013.
In any of that letter, does he ever address the advertisements you found in May, July, and November of 2013?
No, he doesn't address the, just only in passing he addresses, he doesn't address it specifically.
What is the process generally? What happens when someone files a complaint?
When someone files a complaint, I review it and then give it to the complaint coordinator I research it like on the internet if it's a complaint like this one, and then I'll give it to the complaint coordinator, and he will open it and send it out for a response, which is what happened in this situation, and it goes by certified mail. And if it's, hopefully the green card gets back and the person receives it, the person then has a period of time to answer and supply whatever documentation they might have in regard to the matter. And after 14 days, it's sent upstairs to the legal department.
Was an answer filed by Mr. Moore to the complaint sent to him?
Yes, as I say, he received the complaint on July the 10th and signed, it appears he signed for receipt on July the 10th of 2013, and then he sent a letter response on July the 16th of 2013.
And in that response, did he ever talk about whether he was still practicing or not?
No, his letter is, his response is really, it speaks as if he is engaged in practice. It sounds like it's in the present.
In the present.
In the present. Mm-hmm.
Okay. Was this a complaint dismissed as being found without merit?
It was not dismissed as found without merit. Since his firm was expired, the commission never got to the issue of the advertising. They dealt with the fact that the firm had expired, and so they never dealt with it, and they never had to reach the issue of the advertising.
Now, when he wrote this letter, was there a follow-up letter by you to Mr. Moore?
Yes, I emailed Mr. Moore back on January the 27th of 2014.
And what did you tell him in that email? If
you
you
want
don't mind reading it.
Yeah, do you want me to read it?
Please.
Okay. This was sent, as I say, on January the 27th, 2014 at 3:53 p.m. Dear Mr. Moore, I'm sorry that you are unaware the firm license of Real Estate a la carte, LLC, number 259639, expired on 2/1 of 2013. From the time the license is issued, the licensee is on notice that the license expires 2 years from its issuance date, unless the renewal fee is paid and all other conditions of renewal are met. This is true whether the license is in an active status, a retired status, or any other status. No further notice of renewal is required, nor should it be necessary. The status of a license can be checked by looking at the wall or pocket license, going online to the TREC website, or by calling TREC. Each licensee is responsible to make sure that the real estate license is timely renewed. The principal broker is responsible for making sure that the firm license is renewed. During the time the firm license of Real Estate a la carte, LLC, was in an expired status, the firm was advertising its real estate services. While TREC is not required by statute or rule to send out a renewal notice, one was sent to your firm address of record with TREC on 11/5 of 2012, and that notice was not returned by the United States Postal Service. State mail is not forwarded, so mail which is not deliverable is returned to TREC and duly noted in the licensee file. Your file contains no such notation. The waiver of escrow for Real Estate a la carte was approved on 8/24 of 2012. TCA 62, 13, 321, and 323 require that all licensed firms have either an escrow account or an approved waiver escrow. In order to comply with the aforementioned statute, many firms that do not accept escrow monies choose to get an approved waiver of escrow, just as Real Estate a la carte LLC did. The Commission is charged with the responsibility of protecting the public through the enforcement of the Broker Act and the rules and regulations promulgated thereunder. The Commissioners listen carefully to each case which is presented, ask questions if necessary, and after careful discussion and deliberation, make a probable cause determination whether or not the facts and circumstances presented represent actions or conditions which violate the Broker Act and or the rules and regulations promulgated thereunder. In your case, the Commissioners made a determination that your failure to renew the firm license of Real Estate a la carte LLC, number 259639, did constitute a violation of the Broker Act and/or the rules and regulations promulgated thereunder, and voted to issue a consent order. The consent order which was issued in your case does provide you an opportunity to be heard. Once a consent order has been issued pursuant to the vote of the Commission, a formal hearing is the next step, and it is the forum at which the respondent is given an opportunity to appear before the Commission. As Ms. Kropp discussed with you earlier, if you do not wish to comply fully with the terms of the consent order as issued within the time frame provided in the consent order, then you will have the opportunity, at a date to be scheduled later, to appear before the Commission and present your case at a formal hearing. Your attorney can represent you at the formal hearing if you think that would be in your best interest. You can bring witnesses to testify, and you can present the evidence to the Commission to support your position. At the formal hearing, the Commissioners will listen to all of the facts and circumstances and carefully consider the evidence presented and make a determination, and a final order will be issued. I do not know what the decision of the Commissioners will be at the conclusion of the formal hearing. The decision rests solely with the Commissioners, and the Commissioners are the only voting participants. The Commissioners could increase the civil penalty, decrease the civil penalty, and/or order additional penalties. In most previous formal hearings, the Commissioners have charged the respondent with the costs and fees associated with the formal hearing. The costs and fees cannot be determined until after the completion of the hearing, but as Ms. Kropp noted, they usually run from $2,000 to $3,000, depending upon the length of the formal hearing. There is an administrative law judge present who makes decisions regarding strictly procedural matters and takes no part in the decision-making process. There is a stenographer present for the entire formal hearing. There are administrative filing fees and other miscellaneous costs, all of which comprise the total cost of the formal hearing. At this point, there is nothing which I can do regarding the consent order. A complaint was filed, it was presented to the Commission, a decision was made by the Commission, a consent order which embodied the Commission's decision was issued. You as the respondent have the choice to sign the consent order in the time frame provided in the consent order, or go to the next step, which is to take the opportunity to appear at the formal hearing and present your case. If we can answer any other questions, please let us know.
Thank you. That document and the document from him are not a part of the complaint file that was sent to legal, were they?
No, they are not. They were written after the consent order.
Thank you. And did you receive any response to him to this particular letter from you?
No, I did not.
So you heard nothing from him at all since you sent this letter in January?
No, I have not.
Okay. What laws govern firm licenses?
Section of the Broker Act 62-13-309 requires that every firm have a broker, and every firm have a license and have a broker, and have a, it reads 62-13-309 A1A states each office shall have a real estate firm license, a principal broker, and a fixed location with adequate facilities for affiliated licensees located to conform with the zoning laws and ordinances.
Thank you. He said earlier, you said earlier that the principal broker has the responsibility to renew the firm license?
Yes, the principal broker is the person who is the responsible individual for the firm activities.
And am I to understand a notice was sent to him prior to the expiration date of his firm?
A notice, a renewal notice?
Yes.
Is that what you asked? Yes, there was a renewal notice that was sent to him. Find that information. Let's see. It was sent to him on 11/5 of 2012.
And
so it's about 90 days prior to the expiration of the license.
You heard nothing from him about renewing that?
No, we did not hear anything from him, and it doesn't appear that he made any payments. I mean, if his payment screen, and there's no payment for that
now,
time.
in 62, 12.312, Is there exact provision for failing to renew a license as being a violation of the law, subject to penalties?
There's not an exact violation that says that, those very words. 312B14 says, violating any provision of this chapter and any rule duly promulgated and adopted thereunder, or the terms of any lawful order entered by the commission.
And so the 309 would be a violation of, or considered a violation of, under number 14 of 312?
Yes, it would be.
Do you know what the civil penalties, maximums are for violation of that section?
I believe the maximum amount is $1,000.
Per occurrence or per day or per what?
Well, there's a provision that allows for the commission to have a civil penalty up to $1,000 for each day that the violation continues.
Now, his license is currently in retirement.
His individual license, that is correct.
If he were assessed a civil penalty, would that penalty have to be paid before he could take his license out of retirement?
I believe that if it's a final order, then it would have to be paid. And before it could be renewed. I believe that there's a statute that states that.
Okay, and earlier, did you tell me when his license expires?
His personal license? His personal license expires on 7/17 of 2014.
And after that date, how long would he have to renew it?
Well, he'll have a 60-day period of time that he can renew, and there's a penalty of $50 per month, or every 30 days, or any portion thereof. On the 61st day, he can no longer renew it. He goes into the reinstatement phase, and from the 61st day until the 365th day, I guess, he can reinstate his license, and then he would have to pay the applicable penalties and fees that go along with that, attend a meeting, and sign a reinstatement order.
Would he still have to pay the civil penalties assessed to him by an order of this commission?
If there were a final order, it's my understanding that he would.
So even though his license expires in July, there's still a certain amount of time that he could still attempt to put his license back in active status?
That is correct. He has not, as of yesterday afternoon, paid a renewal for his individual license. But as I say, it doesn't expire till 7/17 of 2014, and then you do have a year to reinstate. So he would have until 7/16, really, of 2015.
Now, I earlier gave you a copy of the complaint. Is that the complaint that was sent to legal?
The file that was sent
Yes.
to legal, it didn't contain the letter the email that was dated February of 2014.
But that's because it was not a part of the file then, was sent to legal prior to the commission's review?
Correct. I mean, yes, that's correct.
So does that contain all the information that was sent to legal, including the advertisements?
Yes.
Okay. Your Honor, if the court please, I would like to pass that around and have that entered my next exhibit.
That's the complaint file?
That's correct.
All right, if you will pass up a copy of that, the complaint file will be marked and entered into evidence as exhibit number 2, and you may pass copies to the board.
That is all the questions I have for this complainant at this time. I mean, sorry, you're not a complainant, for this witness at this time.
Thank you, Ms. Ryan. Members of the commission, I'll give you a minute first to look at the exhibit, and then if any of you have questions for Ms. Maxwell, it is your opportunity to ask her questions. Members of the commission, do you all have any questions for Ms. Maxwell?
Ms. Maxwell, you said it was responsibility of the principal broker to make sure the firm license is renewed in a timely fashion. If someone wanted to reactivate Real Estate a la carte LLC today, who could that person be?
I mean, it's expired at this point.
So, but we could bring it back out, right? I mean,
someone would have to file basically a new firm application using that firm name, and then sign as the principal broker on the new firm application, but they could do that at any time. I mean, they're beyond even for a firm, the reinstatement period, so it would be done by, as I say, filing for a new firm application, which would cost $100, and that would start that firm again.
The owner of this company could find him a principal broker and pay the fine or the fee and reopen this company.
Right, or the former principal broker could. I mean, he was a principal broker, Mr. Moore. When we put people in, when people ask to be put in retirement, we put them in retirement. We move them back to a broker, right, so that the privilege tax doesn't pick them up when they're not, not actively licensed. So all he would have to do is fill out a Truck 1, and he could then upgrade back to a principal broker and then apply for the firm license.
Or he could go to work for some other company. And
correct. Or he could, as you say, he could hire someone to be the principal broker, and he could be just an affiliated licensee with that firm.
Thank you.
I have a question. It looks like you're separating the broker from the firm, and the firm is continuing to advertise under the direction of the broker. Is that correct?
Well, I would guess someone's doing the advertising.
Well, it's advertised
and
under
his name was under
the firm name, right?
His name was with the firm name in the advertisements that Ms. Ryan spoke about earlier. She asked me about, that were from July, August, and November. So it was Gary T. Moore, a la carte Realty. I mean, appeared on the same advertising page, or actually there were pages.
Ms. Maxwell, there's no indication that anyone other than Gary Moore owned real estate a la carte, to your knowledge?
Not to my knowledge. He was a principal broker, and he had no affiliated licensees, at least during the most recent time frame that the firm was licensed.
I have one other. When you suggested this be a case, why wasn't it brought against the firm and the broker?
In the past number of years, the complaints, well, actually, this was against the individual. The person alluded to the individual, but we opened them against the principal broker because the principal broker is responsible for the firm, and if there's another owner, we wouldn't, unless they were licensed, we don't have jurisdiction over that person if there was a third-party owner. So we don't, we usually open against the principal broker because they are responsible for the firm. The firm is an entity, and the principal broker is going to have to stand in the place of the firm as it is, so that we open them against the principal broker who can respond.
So when we penalize the broker, we're not penalizing the firm?
But as a principal broker of the firm, you would, I guess, be penalizing the firm as well.
I just didn't understand why we didn't have charges against both entities.
Well, we normally just open it against the principal broker and not the firm, and it's actually the principal broker is in charge of reviewing all advertising and making sure that it complies with the Tennessee Brokers Act and the rules and regulations. So we hold him responsible for making sure that he's compliant with his advertising.
Any other questions by members of the commission? Ms. Ryan, any other questions for Ms. Maxwell?
None.
Thank you. Thank you, Ms. Maxwell.
Your Honor, I would next like to recall Jennifer Smith.
All right. Smith, you were sworn in as a witness earlier, and you remain under oath.
Ms. Smith, you indicated earlier you last heard from Mr. Moore, it looks like I think you said May 21st, is that correct?
Yes, May 21st at 8:09 p.m.
And how did you hear from him?
It was an email from moremedia@att.net.
I'm going to show you a copy of that email and ask you if you can identify it for me. Can I approach?
Yes.
Yes.
Would you please read the entirety from Mr. Moore?
Addressed to me. Okay. Jenica, please feel free to distribute the following in full and directly to the commissioners on the TREC board. Please do not go to any trouble preparing staff or anyone to prosecute me at any proposed meeting or hearing. I will not attend any proceeding in which I am required to pay, especially several $1,000s as staff notes below, to answer a complaint. Staff cut me out of my right to due process by not permitting me to respond to this earlier and in the customary way. I believe the realtors on the commission can affect their common sense and principles and recognize that this complaint does not involve any witnesses, conflicting stories, or any member of the public being harmed. I further believe the realtors will recognize that my having retired my license, not having any transactions or receiving any commissions in more than 2 years, never having any agents under me, and my 37-year track record of serving the best interests of consumers are relevant to this matter. Except for advertising me that you have or have not forwarded this to the commissioners. Please do not contact, or except for advising me, that you have or have not forwarded this to the commissioners. Please do not contact me further about this, as I will not respond to nor accept any further missives. Below is pasted my earlier attempt to reach out to the commissioners individually after an unsatisfactory response from staff. This email below to Gary Bloom went to all other commissioners as well. Sincerely, Gary Moore.
So he sent a copy of something he sent to Commissioner Bloom?
Yes, he pasted an email within the email.
What else is included in that? Or any other communications included in the email to you?
Yes, he also pasted the email to Eve Maxwell that she read, dated January 22nd, 2014 at 10:27 p.m.
And go ahead.
He also pasted an email. I don't have a timestamp on it, just text for an email. He marked out, it said, Dear Mr. XXXX. I guess it was her response. He pasted her response. And then the email that I had sent with the amended notice and notice were also forwarded on that email.
Did you respond at all to this email?
No.
Okay. Have you heard anything more from him?
No.
Your Honor, I would like to pass out a copy of the collective email exhibit to the commissioner and enter that as the next exhibit.
All right, if you'll pass a copy of that up, please, ma'am, that will be marked and entered into evidence as exhibit number 3, and you may pass copies to the commission.
I'll wait till they all get passed up. I have one more question. Ms. Smith, at any time did he ever discuss the crux of this matter, that is, the failure to make sure his firm license was renewed? Did he discuss that with you at all?
No, ma'am.
Okay. And you've not heard from him since this May 21st date, is that correct?
That is correct.
I have nothing further for this witness.
Thank you, Ms. Ryan. Members of the commission, do you all have questions for Ms. Smith? Thank you, Ms. Smith.
That concludes the state's proof, Your Honor.
All right, members of the commission, let's take a short 5-minute break and we'll come back for closing arguments. Do not talk about the case among yourselves or with anyone during the break. Thank you.
That was a long 5-minute break. We're going to take a short one.
They short. They come back within 20 minutes.
They got on to me yesterday.
We've been laughing about that this last couple of days, about a short 10-minute break as opposed to a long 2.
Apparently, we took too short of a 5-minute break.
Yeah. Now, I told you yesterday a short 10-minute break was 9 minutes. Judge Collier said we're going to take a short 5-minute break. That's 4 minutes and 45 seconds, I think. Judge Collier, you're back in charge.
Thank you, Mr. Chairman. Ms. Ryan, do you have a closing argument?
I do.
Go ahead.
You've heard today about how Mr. Moore has said apparently it's everybody's fault he didn't renew it. Everybody's fault but his. He never really entered any kind of argument for why it wasn't renewed, nor did he make an attempt to renew that license. He is the principal broker and was at all times the principal broker of real estate a la carte, and he has and had responsibilities. He also suggested that somehow you guys can use your just common sense and ignore the law. I would suggest to you that you have a very specific law that firms must be licensed under 309. I don't think there's any proof to contradict that at the times that he was advertising and working and even responding that this firm was not licensed. Now, the fact he put his own personal license for retirement doesn't really change anything. To me, it sounds like an avoidance. Like somehow you'll forgive him if he just retires his license and makes the statements he made, or attempts to contact each of you, although you're all smart enough not to read it, attempt to contact each of you in his defense instead of appearing here this morning. Failure to have a firm license is a violation of 6213-309A, I think. Let me make sure so I don't misquote. 309A, 1A. Each firm must have a license. Now, he suggested to you and in various emails that somehow this doesn't harm the public by not having a license. I suggest to you the law wouldn't be there if there wasn't a harm to the public by not having a license. I suggest to you that his cavalier attitude and his attempts at trying to avoid his responsibilities require and should require a penalty. I'll leave it to you to determine what that penalty ought to be. But I am asking that after you consider everything that you've heard today, that you make a finding that he is in violations of the law and that you assess him a civil penalty. And I further ask that after you look at everything today, you decide and determine that because we are here today, because he didn't bother to show, and because he has not bothered to do what he needed to do, he should also be assessed all the court costs in this matter. Thank you.
Thank you, Ms. Ryan. Members of the board, commission, you all have now heard the proof in the matter of the State of Tennessee Department of Commerce and Insurance versus Gary T. Moore, which is docket number 12.18-125451A. It is now my duty to charge you as to the law you must follow in reaching your decision this morning. You are the exclusive judges of the facts in this case. You are also the exclusive judges of the law, specifically your statutes, rules, and regulations, and their application to this case. You should apply the law to the facts in deciding this case under the directions of my charge. You exclusively have the authority to make findings of fact and reach conclusions of law in this case. No one else can participate in your deliberations. However, if you find that you need to have the law or legal terminology explained to you, I can assist you. The state has alleged that the respondent has violated certain of the state's applicable statutes and rules. It is the state's burden of proof in this case. It is the state's burden to prove those allegations by a preponderance of the evidence. Do not confuse this standard with the higher standard of beyond a reasonable doubt used in criminal court proceedings. A preponderance of the evidence means the greater weight of the evidence, or that there is sufficient proven information to cause you to believe that the state's allegations provide the more probable conclusion based upon all of the evidence presented during the hearing. You must limit your inquiry into violations of rules and statutes to those that were specifically alleged in the state's notice of charges and amended notice of charges. Copies of both were handed to you at the beginning of the proceedings. And you must base your determination solely on the evidence presented to you during the hearing this morning. The evidence consists of the testimony given by the witnesses during the hearing and the exhibits introduced into evidence during the hearing. You may review the exhibits during your deliberations. The documents contained in the technical record that I identified at the beginning, which include the notice of charges and the amended notice of charges, are not considered evidence in this case. However, you may rely upon these documents to assist you in making your findings of facts and conclusions of law, but you should do so only after careful consideration and a determination that those documents in the technical record accurately reflect your own independent recollection of the evidence and your own conclusions from the evidence presented during the hearing. Although you may only consider the competent evidence presented during this hearing in making your decisions, this does not mean that you are required to set aside your common knowledge or your expertise in the field of real estate. You may, and in fact, should weigh the evidence in light of your training and your own observations and experience. You should always keep in mind that the state bears the burden of proving the charges. The respondent does not have the burden of proving that he is innocent. Your final order under the Tennessee Administrative Procedures Act should contain 4 sections. Number 1, findings of fact. Number 2, conclusions of law. Number 3, a decision regarding what disciplinary action shall be taken, if any, and if so, what that disciplinary action is. And number 4, the policy reasons for your decision and determination. In making findings of fact, you must make your own evaluation of the testimony and other evidence given during the hearing. You must then give that testimony or other evidence the weight and credibility that you deem proper. You may weigh the evidence in light of your own training and expertise. Once you have made your findings of fact, you must decide if the respondent's activity constitutes a violation of departmental or board rules or state statutes as alleged in the notice of charges and amended notice of charges. And if so, you must state those determinations in your conclusions of law. Your decision must include sufficient analysis of the evidence to clearly demonstrate how the facts of the case support your conclusions. Your conclusions of law should make appropriate specific references to your findings of fact section of your order in order to articulate linkages and connections between these 2 sections of your final order. If you decide that there has been a violation of a state statute or rule, you must then decide what disciplinary action is appropriate in accordance with your legal authority and considering the particular circumstances of this case. You may consider any evidence that the parties have introduced on the issue of the appropriate disciplinary action, including whether the conduct allegedly was or is of a continuing nature or a one-time offense. Additionally, you may also consider what you have done in previous similar cases. Under the law, administrative agencies are not required to have absolute consistency in the disciplinary actions they take. However, this does not mean that you may be arbitrary and capricious in dealing out disciplinary actions. Disciplinary actions must be based on fairness and reason. Finally, a policy reason must accompany your determination to state why the decision you render in this case is appropriate. Your deliberations must be in public before all parties. If you need assistance with the law or the structure of your order, I will be available to assist you. If you have any questions about the facts presented, you may, by a majority vote, reopen the proof and hear further testimony from witnesses and/or argument from counsel. Ms. Ryan, do you have a proposed order?
I do.
All right, if you'll pass that up.
It's actually proposed finding of facts and conclusions law, not an order.
Okay, so she has proposed 2 sections for you of the order, and I'll let her pass that up to you now. Again, this is similar to the documents in the technical record. You may consider the proposed findings of fact and conclusions of law in making your determination. However, please remember that you are not bound by the state's proposed findings and conclusions. Instead, these are only being submitted as a guideline as to what counsel for the state thinks the proof has shown. It is up to you to determine what has actually been proven. And unless there are any questions from members of the panel, I will turn it over to the board chair to preside over your deliberations, after which you will make findings of fact, reach conclusions of law, including a decision regarding whether any disciplinary action shall be taken, and if so, what disciplinary action shall be taken, and finally, to give your policy reason for your decision. And I'm going to enter the document she's just given us, the proposed findings, into the technical record as a technical record entry number 5. Go ahead, Mr. Chairman.
Would look over this proposed findings of facts proposed conclusions of law that Ms. Ryan just passed out to us. Look over those briefly, and then we'll start discussions as we see fit.
Mr. Chairman, I want to make some observations, and then I want to make a motion. And I sense that I'm cutting across the grain, but never been afraid to do that. I don't think this is our brightest hour. I think this was December of 2013. I had to have been here because I remember the meeting, but I don't remember the discussion of this matter. But it looks like we were on a complaint for advertising, and we never got around to the advertising portion of the complaint because we made our determination on unlicensed activity. And I think Mr. Moore never had the opportunity to address why he didn't renew the firm license, which is a due process problem. And in the correspondence there, he talks about maybe coming in for the board and presentation. And I think about yesterday when Mr. Rutledge came. I think if we had afforded Mr. Moore, or if he had enough sense to have just informally appeared before this commission, that the results might be different. It feels like we've got a machine that's just going, and I'm very concerned about the due process aspects of it. Accordingly, I make a motion we dismiss.
You have heard a motion that has been made by Commissioner Flitcroft to dismiss this matter. Is there a second to that motion? Not hearing a second. The motion that Mr. Flitcroft has made, as per Robert's Rules of Order, dies for lack of a second. Does any other commissioners have any observations or thoughts? Or
Chairman,
Mr. Alexander?
I have listened to the facts from our attorney.
Now, I would like to ask that all commissioners, when they talk, just talk a little louder, make sure we can get it on the record.
Thank you. I've listened, I've read. There is always circumstances, but you always have an opportunity to answer those things. In my feeling, he had ample opportunity to come before us. He was invited to. He was asked to, and he refused to. He tells you that he's not going to come. So I disagree with my fellow commissioner. Thank you.
Mr. Chairman,
Commissioner Grease.
I'm prepared to start discussing the findings of fact if this commission is ready.
I think we're probably ready.
I'd like to yield to my colleague, Commissioner McMullen.
Mr. Chairman, I'd like to make a motion that we adopt the following finding of fact. Respondent Gary T. Moore was, at all relevant times pertinent hereto, licensed with the Tennessee Real Estate Commission.
Second.
Have a motion made by Commissioner McMullen, second by Commissioner Grease. You've heard it read into the record. I'm not going to repeat the motion. Any discussion on this motion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries
One
unanimously.
abstain.
Commissioner Flitcroft abstains.
Mr. Chairman, I move that we make the following finding of fact. Respondent was, at all times pertinent hereto, principal broker of Real Estate a la carte LLC, a real estate firm.
Second.
Motion made by Commissioner McMullen, seconded by Commissioner Grease. You've heard the motion read into the record. Any discussion on the motion? Hearing none, all in favor say aye.
Aye.
Opposed, no.
One abstain.
With one abstention, Commissioner Flitcroft.
Mr. Chairman, I move that we make the following finding of fact. On November 5th, 2012, the Tennessee Real Estate Commission sent notice to the respondent of the upcoming expiration of the firm license for real estate a la carte.
Motion by Commissioner McMullen, seconded by Commissioner DeShara. You've heard it, the motion. Any discussion on this motion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman.
One abstain.
One abstention, Commissioner Flitcroft.
Mr. Chairman, I move that we make the following finding of fact. The firm license for real estate a la carte was not renewed.
Second.
Motion by Commissioner McMullen, seconded by Commissioner Grease. You've heard the motion. Any discussion on the motion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries. And
One abstain.
One abstention, Commissioner Flitcroft.
Mr. Chairman, I move that we make the following finding of fact. On February 1st, 2013, the firm license for real estate a la carte expired.
Second.
Motion by Commissioner McMullen, seconded by Commissioner Grease. You've heard the motion. Any discussion on this motion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
One
With
abstain.
one abstention, Commissioner Flitcroft.
Mr. Chairman, I move that we make the following finding of fact. After expiration of the firm license for real estate a la carte, the firm continued to operate.
Second.
Motion by Commissioner McMullen, second by Commissioner Grease. You've heard the motion. Any discussion? All in favor say aye.
Aye.
All opposed, no.
One abstain.
One abstention, Commissioner Flitcroft.
Mr. Chairman, I move that we make the following finding of fact. The operations of real estate a la carte after the expiration of the firm license include online internet postings advertising real estate for sale.
Second.
Motion by Commissioner McMullen, seconded by Commissioner Grease. Any discussion on this motion? All in favor say aye.
Aye.
Opposed, no.
One
One abstention, Commissioner Flitcroft.
Mr. Chairman, I move that we make the following finding of fact. These advertisements include an advertisement viewed November 22nd, 2013 at the internet website www.realestatealacarte.org. This advertisement uses the Real Estate a la carte name, logo, and address, the name and telephone number of the respondent, and email addresses using the domain realcarte.com. This advertisement includes details about the, quote, revolutionary real estate a la carte system, unquote, and lists properties for sale.
Heard the motion by Commissioner McMullen. Do I hear a second?
Second.
Commissioner DeShara seconds the motion. Any discussion on this motion? Hearing none, all in favor say aye.
Aye.
Opposed, no.
Abstain.
One abstention, Commissioner Flitcroft.
Mr. Chairman, I move that we make the following findings of fact. As of the date of this notice of hearing and charges, Real Estate a la carte LLC remains in an expired license status.
Second.
Motion by Commissioner McMullen, seconded by Commissioner Grease. You've heard the motion. Any discussion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
One
abstention, Commissioner Flitcroft.
Mr. Chairman, I move that we make the following finding of fact. As of the date of this notice of hearing and charges, respondent's license is in retired status with an expiration date of July 17, 2014.
Motion by Commissioner McMullen, seconded by Commissioner Grease. Any discussion on this motion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
One abstain.
One abstention, Commissioner Flitcroft.
If there are no other findings of fact, I would propose that we move on to conclusions of law.
Any other commissioners have any additional proposed findings of fact that they would like to discuss or make a motion about?
The only one Commissioners, was the email evidence that he didn't plan to attend this hearing? Is that pertinent to this, in your opinion, Commissioner McMullen?
We could include that. We had already moved to go forward with to proceed in default. I don't know if it would be wise for us to include additional reasons for that or not.
Your order, once it's prepared by council, will include a section on default because that's required. It's probably not going to have any factual findings since you all haven't instructed them on what to put there. So if there is a particular fact that you want to put in the facts section, you're of course open to do so.
Where was that? Do you remember that in the
Danica?
Exhibits that we have?
It's in an exhibit. If you go to the May 21st, 2014.
Exhibit 3, I think.
Court reporter thinks it's Exhibit 3.
Exhibit 3.
Fourth paragraph down, it says, except for...
On which page?
On the front page.
Okay.
Except for advising me that you have or have not forwarded this to the commissioners, please do not contact me further about this, as I will not respond to nor accept any further missives. I'm not sure what a missive is, but...
More than one message.
Thank you. I'm not sure that's pertinent. I just want to put it out there to discuss.
I'll make a motion that we make the following finding of fact. By email dated May 21, 2014, to Tennessee Real Estate Commission staff, the respondent stated, quote, "Please do not go to any trouble preparing staff or anyone to prosecute me at any proposed meeting or hearing. I will not attend any proceeding in which I am required to pay, especially several $1,000s as staff notes below, to answer a complaint," unquote. The email continues, quote, "Except for advising me that you have or have not forwarded this to the commissioners, please do not contact me further about this, as I will not respond to nor accept any further missives," unquote.
Second.
I have a motion that you have heard read into the record by Commissioner McMullen. It has been seconded by Commissioner Grease. Any discussion on this motion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
One abstain.
And one abstention, Commissioner Flitcroft. Any other findings of fact that anybody wants to discuss or make a motion about? If not, then we're going to move on to the proposed conclusions of law.
Mr. Chairman, I move that we make the following conclusion of law. Section 62-13-312B14, Tennessee Code Annotated, provides, quote, "The Commission shall have the power to refuse a license for cause or to suspend or revoke a license where it has been obtained by false representation or by fraudulent act or conduct, or where a licensee, in performing or attempting to perform any of the acts mentioned herein, is found guilty of violating any provision of this chapter, any rule duly promulgated and adopted thereunder, or the terms of any lawful order entered by the Commission."
Second.
I have a motion by Commissioner McMullen and seconded by Commissioner DeShara. Any discussion on this motion? Hearing none, all in favor say aye. Aye. Opposed, no. With one abstention, Commissioner Flitcroft.
Mr. Chairman, I move that we make the following conclusion of law. Section 62-13-309A1A, Tennessee Code Annotated, provides, quote, "Each office shall have a real estate firm license, a principal broker, and a fixed location with adequate facilities for affiliated licenses, located to conform with zoning laws and ordinances."
Second.
Motion by Commissioner McMullen, second by Commissioner Grease. You heard the motion. Any discussion on this motion? Hearing none, all in favor say aye.
Aye.
Opposed, no.
One abstention.
And one abstention, Commissioner Flitcroft.
Mr. Chairman, I move that we make the following conclusion of law. Rule 1260-2-.321, Rules of the Tennessee Real Estate Commission provides, quote, "The commission may, in a lawful proceeding respecting any person required to be licensed by the commission, in addition to or in lieu of any other lawful disciplinary action, assess a civil penalty for each separate violation of a statute, rule, or order pertaining to the commission with the following schedule. Violation TCA Section 62-13-312B14. Penalty $300 to $1,000.
Second.
Heard a motion made by Commissioner McMullen, and it's been seconded by Commissioner DeShara. Any discussion or comments on this motion? Hearing none, all in favor say aye.
Aye.
Opposed, no.
One abstention.
Commissioner Flitcroft has abstained from the vote.
Mr. Chairman, I move that we make the following conclusion of law. Section 56-1-311A, Tennessee Code Annotated, provides, quote, "Any board, commission, or agency attached to the Division of Regulatory Boards may assess the actual and reasonable costs of the investigation, prosecution, and hearing of any disciplinary action held in accordance with the contested case provisions of the Uniform Administrative Procedures Act, compiled in Title IV, Chapter 5, Part 3, and in which sanctions of any kind are imposed on any person or entity required to be licensed, permitted, registered, or otherwise authorized by the division or respective board, commission, or agency. These costs may include, but are not limited to, those incurred and assessed for the time of the prosecuting attorneys, investigators, expert witnesses, administrative judges, and any other persons involved in the investigation, prosecution, and hearing of the action."
Second.
I have a motion by Commissioner McMullen and seconded by Commissioner Grease. Any discussion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries with one abstention, Commissioner Flitcroft.
Have any other conclusions of law? If there aren't any others, I would suggest that we move on to the disciplinary action phase of the hearing.
Any commissioners?
I have one I want to throw out. He is continuing to advertise and without a legal firm. Is that not a penalty also? Under 1260-3-12B?
Section?
Which section was that again, Commissioner?
1260-2-.4B. I think we are limited by the charges that are listed in the amended notice of hearing and charges, and I don't think that that particular charge was included in the notice of hearing and charges, and so on that basis, I don't think we can go forward on a charge based on that.
Yeah.
And I would agree with Commissioner McMullen.
Yeah, I was getting ready to say, Judge Collier, when we first started, alluded to that we can only address the things that have been given to us in the proposed findings of facts with the charges, and that was not one of them. Even though, yes, I agree with you, Commissioner Collins. After looking at the things that was in Exhibit 2, that in fact is factual, but it's not something that we're charged with addressing in this hearing.
Thank you.
Commissioner McMullen, do you have a direction you'd like to suggest for disciplinary action?
Sure. Mr. Chairman, I move that we impose on the respondent a civil penalty in the amount of $1,000 based on the firm of which he is the principal broker's continued operations and advertisements after February 1st of 2013, when the firm license expired, which constitute a violation of Section 6213-309A1A, and thus also a violation of Section 6213-312B14.
Second.
Heard a motion made by Commissioner McMullen, seconded by Commissioner DeShara. Does anybody have any discussion on this motion?
Do you want to plan to amend that motion or add a second motion?
I'm open to whatever the commission wants to do. I'm not firmly tied to that number and think that that's a topic for discussion.
I'm okay with the number. I just want to make sure that my suggestion is that the costs of this hearing be assessed to the respondent as well.
Right.
Well, and
Yeah.
again, right now he's talking about civil penalties, whereas the costs are not part of the civil penalties.
Okay. Thank you.
That could be a further disciplinary action.
You've heard the motion made by Commissioner McMullen and tied to the authority that we have as the Tennessee Real Estate Commission by our statute of civil penalty of $1,000, and it was duly seconded by Commissioner DeShara. Any other
Is that
comments?
$1,000 one time or per day?
His motion is $1,000 just one time. Any other discussion or comments? If not, all in favor say aye. Aye. Opposed, no.
No.
Motion carries with one abstention. Commissioner?
No.
Oh, he voted
I
no.
vote no.
You voted no. Okay, I'm sorry. The vote was 6-1. Anything else?
Mr. Chairman, I further move that we impose all costs of investigation and hearing costs pursuant to Tennessee Code Annotated 56-1-311 and Rule 0780-5-11-.01 of the Tennessee compiled rules.
Second.
Motion by Commissioner McMullen that in the matter of Gary T. Moore, license number 16853, also be assessed with the cost, investigatory cost, and all the cost of these proceedings. Any discussion on the motion? Hearing none, all in favor say aye.
Aye.
Opposed, no.
No.
Commissioner Flitcroft votes no. Motion carries.
Mr. Chairman, I don't have any other proposed disciplinary actions and would suggest we move on to the policy reasons if there are no other motions with respect to disciplinary actions.
Do I have any other motions they'd like to make pertaining to the...
Mr. Collins, I think had a question.
Were we not charged to revoke his license?
No. State did not.
We can do that.
Did you not put it in the charge?
Yes, you may, Ms. Ryan.
Yes, that is included in the charge because the section of code on which I was going under allows you to revoke or suspend or authorize any other civil penalties or penalties for violations of the code. While I did not, and I am not making any suggestion of any sort, that was included in the notice of hearing.
Thank you.
Commissioner Collins, it's my understanding, I mean, that is definitely within our authority as the Real Estate Commission, but, you know, correct me if I'm wrong, but...
Mr. Chairman, I'm afraid if we don't do something, it's going to come back and haunt us on either the firm or him 2 months from now.
Because right now, all he has to do is pay his renewal license in July, and he is still operating, and then can take the firm and pay $100 and bring it back into an operating firm.
You also have to pay in the civil penalty and costs and things that we've assessed here.
Prior to any renewal, yes.
Yes, yeah, he'll have to, whatever penalty that we impose, civil penalty that's imposed upon him, he will have to pay before he can address and get back into business of.
Mr. Chairman,
Commissioner Alexander.
I move that his license be suspended from this day for 18 months.
Just his or his and the firm's?
Talking about his individual. If you suspend his individual license, he can't open the firm.
I'll second that.
We have a motion by Commissioner Alexander that Mr. Gary T. Moore's license number 16853 be suspended for 18 months starting today. And it's been seconded by Commissioner DeShara. Discussion on the motion.
Mr. Chairman, Commissioner Alexander, I really don't know that there was any harm done to any entity other than the state of Tennessee. There were no individuals who were harmed, no money that was held. And to me, that's a little bit of an overkill. I suspect this guy's license is going to expire in July and he's going to be through, but I don't know that. But I would speak against the motion just because if he meets the conditions we've put on in the first two disciplinary actions, I suspect that's enough from my perspective.
Vice Chairman Grease, and speaking against your motion, that means if anybody violates our advertising law, we just might as well toss it out the window, because
We're not hearing advertising today.
Yeah, we're not addressing that.
but he's violating our rules now, and he's on an inactive status.
Mr. Grease, I would agree with you. Had those, even though we're not charging him with advertising violation, he continues to leave them on the internet. If he had ceased to do that, so how do I know that he has not closed any or sold any, made any sales? Because if he's not, how would we know that? How do you know that?
I don't, but that was not, in my opinion, what was in front of us today. I mean, there was testimony that indicated he was still practicing real estate clearly, and I think that's what the charge was about, but I don't think it was advertising. And we have our discussions and differences from time to time, which I think is fine, but I think in this particular case, the sanctions already voted on are enough.
Well, that's fine. I have a motion on the floor that's been seconded, and I call for the question, voted up or down.
Ms. Maxwell, can you judge? We can, customarily, Ms. Maxwell handles our roll call votes.
We'll let her handle one today.
Not alphabetically, though.
Go around the room.
Okay, so this is a vote whether or not to suspend the license of Gary T. Moore for 18 months beginning today.
Correct.
Which technically, it will begin the day the order is filed in my office.
Fine.
Because that's the date, so it would be the suspension effective the date the final order is entered, which is when it's filed with APD.
I'm gonna write that down real fast.
Want me to say it again?
The date the final order is entered.
It's filed with APD.
Okay,
Yeah, which that's the date it's entered.
okay, thank you.
And that's usually within a week or two. It's not, I just wanted y'all to understand that it really isn't today.
That just makes it that much longer, so that's all right.
Okay, so that is the motion upon which you're voting. Flitcroft?
No.
Franks? Oh, she's not up there, recused. Alexander?
Yes, I vote for the motion.
McMullen?
No.
Bloom is not here. Collins?
Yes.
Grease?
No.
DeChara?
Yes.
Stevenson?
No.
The motion fails 4 noes to 3 yeses.
Anybody have anything else that they want to enter into the proceedings? If not, I guess we're ready to move on to our policy statement, if somebody would like to enter a policy statement into the record.
Mr. Chairman, I move that we adopt the following policy statement. The Tennessee Real Estate Broker License Act of 1973 places the responsibility for the administration of the Brokers Act on the Tennessee Real Estate Commission. Licensing of firms and individuals is an important part of the Commission's work to regulate this industry and to protect the public. Having a firm continuing to operate after expiration of the firm license presents an enhanced risk to the public, which justifies imposition of civil penalties and costs and expenses in this case.
You've heard what Commissioner McMullen has read into the record as a policy statement in this matter. Do I hear a second to his
Second.
record? Seconded by Commissioner DeShara. Any additions or corrections anybody want to speak to or against the motion that Commissioner McMullen has made? Hearing nothing, all in favor say aye.
Aye.
Opposed, no.
One abstain.
One abstention, Commissioner Flitcroft. Judge Collier, I think we have completed our proceedings and our findings of fact, our conclusions of law. We've made a decision and we've read a policy statement into the record, and I think that this commission has finished what we have been charged to do.
I think you have too. Thank you, members of the commission. And Ms. Ryan, if you will draw up the order per the commission's deliberations and have that signed by the chair and filed in APD, it will become effective the day it's filed in APD. And these proceedings are adjourned. And I will turn it back to you, Mr. Chairman, in case y'all have more board business.
Thank you, Judge Collier. We always like having you. You do a good job. And we got our visiting judge, Michael Bagley, over here. I said before these proceedings started, I said, you're going to be learning at the foot of the master today, because you always do such a good job, Judge Collier, and we appreciate it when we get you.
Thank you, Mr. Chairman. I enjoy being here.
Oh, I think this is the only thing that's on the agenda for today. And Commissioner reports. We're going to be here again the 2nd and 3rd of July.
Not the 3rd.
Not the 3rd, just the 2nd. We have a one-day meeting, but understand we're going to have something special on Tuesday night on the
All I want him to do is put the big pot in the little one.
Anybody have any? Commissioner Alexander, you have any?
Sir, I think I spoke enough for the last 2 days.
Commissioner Grease.
I would like to note, in the unlikely event that my two colleagues from East Tennessee aren't with us next month, which I find highly unlikely, I would like to personally thank them both for the leadership they've shown on this commission and wish them well. But on the other hand, I don't want to kick them out too soon, so I'm not trying to make it a final statement forever.
Yeah, only time will tell. Commissioner DeShara.
Oh, you're not skipping me today,
No,
huh?
I'm not going to skip you today.
Well, I would echo Commissioner Grease's comments about our two commissioners from East Tennessee whose term expires the end of this month. We do hope the governor doesn't get too hasty in appointing replacements, but if he does, it's been a pleasure serving with both of you gentlemen. And Dave, you're still my hero for killing big bugs that are after me.
Mr. Collins.
I'd like to echo what Janet and John said. I've enjoyed serving with both of you, and I think we've had a good meeting. Thank you.
Commissioner McMullen.
I will concur wholeheartedly in the statements of my other commissioners and look forward to hopefully continuing to work with you fellas for a little bit longer.
I've given this some thought, and I love the real estate community. It's kind of like practicing law, is if you don't get up and go to work in the morning, you don't earn any money. And this commission has been my lifeblood for the last, I'm guessing 8 years. Bear, has it been 8 years?
Mm-hmm.
Almost?
Yep.
Almost. And I'm certainly going to miss it. Folks, let me tell you something. The two days that we spend on the commission things, we make $50 a day. Not a great deal, but these people that we have here with you, the staff, the lawyers, they do a tremendous job. And I'm just so proud to have had the opportunity to serve with them. And I've learned a lot. Thank you.
You can't serve on this commission without learning a whole lot.
We've learned a lot about you, Bear.
This is true, but please don't tell it. And
The two leaving have lost their hair.
Marcia Franks, you can come up here and join in too, because the proceeding is over. You got an opportunity to speak.
Well, I've only been here since January, but Bear and David, you both have taught me a lot. I've learned a lot about procedures and real estate law, and just appreciate you all so much, and hope that next month you'll still be here with us. And if not, Godspeed always, and good luck to you.
Thank you, Commissioner Franks.
I still don't have anything to say. So both of you know how I feel, so why should I?
Commissioner Flitcroft came on the commission. There was about 3 years remaining on a consumer member's term from East Tennessee, and the Governor Bredesen appointed him to fill out the remaining approximately 3-year term, and then he was reappointed to a 5-year term. So Commissioner Flitcroft has been on the commission. I swore I wasn't going to do this, but he's been on approximately 8 years. I have been on here 10, and I'm going to miss it. In the last 2 years I've been chairman, and I have just, it's meant a lot to me, the friendships that I have made, the licensees that I've met. This has been a special time in the 10 years of my life, and I wanted to thank all of you for making it special to me. And I will be on the commission officially, because the statute says you continue to serve until the governor appoints your replacement. But officially, my term ends June the 30th as of midnight, here in another 25 days or so. But I hope, too, that the governor's not in any hurry to make my appointed replacement. But it's been a heck of a journey, and it's been fun. And I want to encourage all of you, I hope you've learned something, you licensees, from having been here the last 2 days, that you can take back and take this home and share it with your other licensees in the firms where you work. Just let them know that the things that we do in this commission, with all of the 23,300 plus licensees that we have, that you share it with as many of those as you can. And we hope that you have a good year remaining this year, and we will see you at some point in the future.
Sign out.
Yeah, sign out, and your certificates are on the back. All you licensees are here for reinstatement of continuing education. This meeting is officially adjourned.
Adjourned.
You're not supposed to do that. You made me cry.
Thank you, Judge.
You're welcome.
Great job.
Fun day.
Oh.